These are basically the clauses which are there in the end of the agreement when the operative portion of the agreement has been drafted. So primarily how the agreement is usually drafted, what is the flow of the agreement, is it starts with the recital, wherein you basically explain what is the agreement all about. Then you come to the definitions. Then is the operative part of the agreement. Operative part in crude terms means कि क्या क्या होगा उस agreement. Suppose it's a share purchase agreement, तो shares कैसे purchase हो? Services agreement, तो services कैसे render होंगे? और after that there are termination and end game clauses कि agreement खत्म कैसे? The last bit, which is usually put under the category of miscellaneous or general clauses, are the boilerplate clauses. These are usually standard clauses which are used in every contract, and sometimes due importance is not given to them, but these are very important clauses, and these needs to be reviewed and drafted in a manner so that there is no problem in the future. I'll give you a very basic example. Force majeure is a classic boilerplate clause. During COVID time, everyone knows services and basically supply of goods, everything was affected. Many of the companies could not perform their services because of the COVID, unavailability of people or other things. They were not able to perform. They had neglected their force majeure clause, in which if it was mentioned that if the services are not able to be performed because of any natural event which is outside the control of parties, no party will be liable. If they had that force majeure clause, obviously they were saved from breach and consequent damages. If they did not have, they had to perform the part of the contract, and there were legal obligations and legal complications for them. So the importance of boilerplate clauses cannot be stressed enough, and you should have clear and certain boilerplate clauses which helps you to avoid dispute and avoid the breach of the contract.